Hello everyone. Today we're going to look at one of my favorite television shows, Judge Judy, to learn some legal concepts. Hello everyone. Welcome back to LegalChat JA. I am Kimberley Downer and I am an attorney at law. And today we're going to learn some key concepts from an episode of Judge Judy.
All parties in the matter of Gamble versus Griffin. Step forward.
Ashley Gamble is suing her former landlord, Michael Griffin, for the return of her security deposit. Michael is countersuing for defamation, slander, and an unpaid water bill.
Now, what is a counterclaim? A counterclaim is a claim made by the defendant against a plaintiff. So in this case, she is the plaintiff and she is suing for the return of her security deposit. He is the landlord and he is countersuing for water that he says she left outstanding.
Ms. Gamble, the defendant was your landlord.
Yes.
And he's no longer your landlord. You moved out and you want your security deposit back.
Yes.
Mr. Griffin has a counterclaim. He says you owe for a substantial water bill.
Yes.
When did you move in and what kind of premises?
June 12, 2015, into a home, 2-bedroom,
What was your rent?
$750.
And how much security deposit did you put down?
$750.
So that's $750 that's at issue today.
Yes.
Why are you suing him for $1,500?
In the state of Pennsylvania, if he doesn't give me my security deposit back within 30 days, it doubles.
Well, in Jamaica, that's not the case. If the landlord is required to give back the security deposit, then it is only the security deposit that was taken that can be sued for. Now, if the judge here in Jamaica grants judgment in favor of the tenant and tells the landlord to pay the tenant, the judge may also award something called costs. So the judge may tell the landlord that he has to pay some of the attorney's fees, costs to file the claim, and also costs to serve the claim. So that's why it's always good to try and settle a matter quickly before you actually get to court. If not, it could just cost you in the end.
You moved out on the 11th?
No, January 5th, 2016.
Was it a 6-month lease?
Yes.
Do you have a lease?
Yes.
I see it.
We actually agreed that I would move out on the 5th of January.
Well, actually, it begins June 12th, 2015 and ends June 11th, 2016. So tell me why you moved out January.
I was having difficulty. I lost my job. I was pregnant. So I was having difficulty paying rent. So we agreed that I would move out January 5th.
Do you have that someplace in writing?
Yes.
When did you advise Mr. Griffin that you wanted to move out earlier?
December 15th of 2015.
Did you pay rent in December?
Yes.
Did you pay him his judgment?
Yes, I have.
Is that correct?
It is.
Okay, so people, the young lady signed a lease agreement, which was a 1-year lease agreement. However, 6 months into the contract, she lost her job, she got pregnant, and she encountered financial difficulties. This is what she says. So she speaks with her landlord and agrees with him for her to leave on the 5th of January. That's the following year. Now, notice what Judge Judy asks her. Judge Judy asks her, do you have this in writing? Now, people, very important. If you want a written contract to be modified, then I would encourage you to do so in writing and make sure that all contracting parties sign the modification. This is very important, especially in the case where the contract says that any modifications or amendments must be done in writing and signed by both parties. When the contract states that the amendments have to be done in writing and signed by both parties or any contracting parties, it is highly likely that the person's claim that there was an oral agreement might just be thrown out if there was nothing written. In the event that a clause stating that the amendments to the contract must be done in writing is not included in the contract, then my advice is to still put it in writing. You always hear me talking about oral agreements. Oral agreements may prove to be difficult to prove in court. Sometimes people come to court and lie and say that there was no agreement. The judge would have to then decipher as to who is telling the truth and who is not telling the truth. Another thing that I want to point out is that communication is always key in any relationship. Here, as you saw, the tenant faced a problem. So she spoke with her landlord about it and they came to an agreement. If her landlord did not agree for her to terminate the lease early, then she would have to find some way and pay that remaining 6 months lease. If she had just left the rented premises and did not communicate her difficulties to the landlord, then she still will be liable to pay the landlord the remaining 6 months lease. So what the tenant did was a good thing. And so I want to encourage all of you to communicate, because guess what? Life happens. And let us also be understanding of each other.
I filed for eviction. We didn't agree on a 6-month lease at all. And upon me filing for eviction, waiting for her to receive the funds to pay me the settlement, a water bill came.
She's not responsible for water in your lease.
No, she was responsible for the water.
No, she's not responsible for water in your lease. Show me where. It says she's responsible for the following utilities: electricity and gas.
There was no gas in the house. It's just all electric.
Mr. Griffin, I assume that Ms. Gamble did not pay to have this residential agreement letter prepared, that your company prepared the lease.
Well, we had a verbal agreement that they would pay.
You don't have a verbal agreement when you have a written lease. When you have a written lease, the 4 corners of the agreement form the entire agreement unless it is modified in writing and signed by both parties. Your lease provides that she is responsible for gas and electric. If there was no gas, then she's not responsible for gas, but she's not responsible for water.
Okay.
So now that you understand that, because all you had to do was look at the lease.
Right.
And it says gas and electric. Your counterclaim is for water.
My counterclaim, when she rented the house, the 3 things that she asked me, her and her boyfriend at the time, asked me what would they be paying, was water.
Listen to me.
I'm listening.
4 corners of the agreement that you prepared. Utilities, she's responsible for gas and electric. That's what it says.
Okay.
So you have to give her security deposit back. That's what the judgment says. Judgment for the plaintiff in the amount of $750. Counterclaims dismissed. We're done.
No, as you see, it's very important that you read over your contracts to make sure that you don't leave anything out. The contract said electricity and gas. It didn't say electricity, gas, and water would be the responsibility of the tenant. And when you look at this agreement, you see it's one of those agreements that you fill in the information. So perhaps he got the agreement online and didn't read through it properly. He probably saw the word utilities and thought that it covered everything. This is one of the dangers that people run into when they don't read contracts properly and rely on the internet to draft their contracts for them. A contract is personal, so make sure that whatever you discussed and agreed are incorporated in the written contract. Yes, so legal chatters, here are 3 takeaway points today. 1, when there is a need to make an amendment to a contract, ensure that you have both parties or all parties agreeing to the amendment in writing. 2, make sure you read over your contracts carefully. And 3, anything that you wish to be incorporated into the contract, ensure that it is in the contract. That's it for this week's episode of Legal Chat JA. I hope you learned something. I did enjoy, and I always enjoy watching Judge Judy. Please be sure to like, share, and subscribe, and turn on that notification bell so that you don't miss an episode. Until next time, let's keep legally informed. Bye.